Members, please sign in again if you haven't already for the new committee, please. Members, this meeting of the House Government Operations Committee for March 31, 2025 will come to order. Clerk, if you would take the roll. Everybody here that wants to be? Sorry, wrong way to phrase that. Everybody checked in that's here. That's Faison. All right, Clerk, please take the roll.
Mr. Chairman, there are 15 members present. You have a quorum.
Thank you for that. Members, item number 7, House Bill 484 has been subbed in the Senate, so we're going to take it off notice at the request of the sponsor. We're also going to go out of order just a little bit. Chairman Reedy has got another obligation coming up here in a little while, so we're going to do something that's not usually done. We're going to take up my bill first in order to free him up at the end. So with that, I will hand the gavel. Oh, I'm sorry. Before I'm getting ahead of myself. Do we have any personal orders, members? All right, seeing none. Chairman Reedy, if you would, please.
Thank you, Mr. Chairman. Members, item number 11, House Bill 270 by Chairman Lafferty. We've got a motion and a second. Chairman Lafferty, you're recognized on your bill, sir.
Thank you for that. This is one of our sunset bills. It will extend the Tennessee Emergency Management Agency until June the 30th of 2029. With that, I'll take any questions.
Thank you. Any questions, comments to the chairman on the bill? Seeing none, are we ready to vote? Clerk, please open the board for the vote, please. Has everyone voted? Anyone would like to change their vote? Seeing none. Clerk, please call out the vote.
Mr. Chairman, the vote is 14 ayes and 0 noes.
Thank you, sir. Bill moves out to calendar and rules. Chairman Lafferty, the gavel is yours, sir.
Thank you, Chairman. Appreciate that. All right, members. We've got first item on the calendar, House Bill 1302 by Leader Lamberth, being presented by Jones of Unicoi. We have a motion and a second. Representative Jones, you are recognized.
Thank you, Mr. Chairman. What this bill does is it brings our meat inspection program into alignment with the federal inspection safety program, food safety program. So the commissioner will be promulgating the rules and in charge of implementation of this program. So with that, I stand ready for questions.
Thank you for that. Members, do we have any questions? Representative Renaud, you're recognized.
Thank you, Mr. Chairman. Sponsor, the bill says that further processing of USDA or state inspected products is not covered under this bill. Can you just confirm that it's still legal but would be covered otherwise under the other laws that is already in place?
Yes, ma'am. It would be, as this just brings us into what the alignment of the federal guidelines are, but everything else would stay the same.
You're recognized.
So just to confirm that the Tennessee Poultry Act would still remain separate, standalone, the rabbit processing would be standalone?
Yes,
Thank you.
ma'am.
Representative Clemens, you're recognized.
Thank you, Mr. Chairman. Can you, just for the record, which draft of this bill are we working from?
5116.
5116. Okay, thank you. So,
You're recognized.
thank you, Mr. Chair. So in here, we adopt several standards and federal regulations, pages 4, 5, or pages 5 and 6 rather of this. And I know that several sections are left out that are contained in the federal code, such as a couple of pertinent issues with regards to bribery, gifts, storage, handling regulations, certificate of conditions, things like that. Why are those specific sections excluded from adoption under this?
You're recognized.
So I'm not aware of that, but we do have the Department of Ag here that can probably answer those questions for you.
Thank you. And thank you, Mr. Chairman. And so with regards to this, allowing the department to handle this inspection, are we creating a new level of bureaucracy here, something that's already being handled by another federal agency? Or why are we recreating the wheel here? Or why is this being
So-
necessary?
Mr. Chairman?
You're recognized.
Thank you. So the way it is worked right now, in order to get the federal, to comply with the federal program, which we have to do in order to get the dollars from the federal program, in order to carry out this program, we have to meet certain guidelines. So we're not really creating another level. It's just a parallel to get us parallel with the federal government.
You're recognized.
Thank you, Mr. Chairman. And so then my question would be, why are we excluding certain provisions, again, as I asked previously, from adoption? I know some of them deal with exporting and things like that, but there are other pertinent ones that I was just curious as to why we're excluding. And I understand if you don't have that answer. Thank you.
Thank you.
Thank you for that. Next up, I've got Chairman Reedy.
Thank you, Mr. Chairman. And to answer a lot of questions, if you recall, a couple of years ago, I did have the meat inspection bill, and we're going through a process. Members, keeping in mind that USDA will still be inspecting in those USDA inspected facilities, keeping in mind those facilities, they have got a veterinarian watching the animal be unloaded, the processing, and then watching it go out the front door. Our concern was during COVID time, a lot of those packing houses were shut down because of USDA. Now, many states, and I think it's 31 something, other states are currently doing this, and this is bringing it forward because we do have to work through USDA. In other words, the same inspections that they are doing, we will be doing locally with our own staff in the state of Tennessee. What does that mean to me as a farmer? Well, I'm able to take that to my local butcher shop, that it will be part of this program. Now, there'll be a reimbursement from the federal government, and that's the financials that you're looking at in the document. And part of that is I'm able to sell to you. Let's say that you've got a church picnic and you want 300 pounds of ground beef. I could sell that to you. But right now, I have to sell you a half of a cow or a full cow. I cannot sell partially. So this is going to move us into the new century on how we're going to take care of Tennessee farmers and those folks who want to eat locally instead of worrying about where your beef's coming from, another country or another state. Thank you, Mr. Chairman.
Thank you for that explanation. Well done, sir. Thank you. Next up, we have Representative Parkinson. Oh, all right. Any other questions for the sponsor? We have a question on the bill. Clerk, please open the vote. Everyone voted? Anyone wish to change their vote? Clerk, please take the vote.
Mr. Chairman, the vote is 15 ayes and 0 noes.
Thank you for that. You're on your way to Finance, Ways and Means.
Thank you, Mr. Chairman and committee.
And you also have item number 10, I see.
I do. This is a bill that deals with the.
I'm sorry.
I'm sorry.
We need a motion and a second. We have a motion and a second on House Bill 589. You're recognized.
Thank you, Mr. Chairman. Sorry about that.
No worries.
So this is the Agricultural Hall of Fame. We're just basically changing the name and doing some updating on this Hall of Fame to the Tennessee Agriculture and Forestry Hall of Fame. This will be the board is administratively attached to the Department of Agriculture, and they will promulgate the rules moving forward with this.
Easy enough. Members, any questions? Oh, Representative Renaud, you're recognized.
Thank you, Mr. Chairman. I just have one question. I was curious, just for my knowledge, there are different terms for the appointed members, and just wondering why the different members from the different districts, whether it was the Eastern, Middle, or Western, would have different term appointments.
You recognized? You recognized?
Yes. So it just, I'm not sure I understand your question.
Representative Renaud?
Thank you, Mr. Chairman. It says that we've got a member appointed to the Middle Division, Eastern Division, Western Division, but then it seems like they each have different terms. One's for a 6-year term, one's for a 4-year term, and one's for a 2-year term. So I was just curious why they would have different terms.
So that, yes, sir, thank you. So that just is to stagger the terms, because the ones that are there now, as we're formulating the rules on the new terms and the new members, it just is to stagger the terms so that it doesn't change anything, just staggers the terms.
Thank you.
All right. Thank you for that. Members, any other questions? Representative Crawford, Chairman Crawford.
Thank you, Mr. Chairman. I just had a simple question here. Basically, what this bill is doing is you're taking the board of the Tennessee Agriculture Hall of Fame and reconstituting it. Is that correct?
That's correct.
Thank you.
All right. Members, any further questions? Seeing none. With that, Madam Clerk, open the vote, please. Everyone voted? Anyone looking to change a vote? All right. Clerk, please take the vote.
Mr. Chairman, the vote is 15 ayes and 0 noes.
Thank you for that. You're on your way to calendar and rules.
Thank you, Committee and Chairman.
Item 2, House Bill 1310 by Representative Helton Haynes. We have a motion and a second. Representative, you are recognized.
Thank you, Mr. Chairman. This legislation is a modernization and cleanup of the environmental health statutes. This legislation does 6 things to add in deregulation. First, this legislation will allow for food and safety code to be modified by rule rather than through statute. This is a significant change because it will give the department more flexibility to work with industry partners to update and modify food code as necessary. Secondly, this legislation deletes duplicate statutes regarding the rented premises unfit for habitation laws. Removing this citation will result in a cleaner, easier to read code. Third, this legislation updates the definition of a campground to exclude RV parks with no group amenities and year-round tenants. Fourth, this legislation will allow for pool inspections to occur once every 3 months instead of the current once per month. There has been an additional safeguard put in place that would allow for the commissioner to deem more inspections if necessary. Fifth, this legislation decreased the number of inspections required for bed and breakfasts that are currently registered in the state. These bed and breakfasts would be inspected yearly, making it more aligned with the other rental properties in the state. And number 6, it limits fee increases in proposed rules to no more than 3% per year and no more than 5% over a 5-year period. This was an amendment that was worked on in collaboration with the food service industry, the Department of Health, hospitality, grocery stores, and convenience stores. We all worked with them with the stakeholders. And with that, I stand for questions.
Thank you for that explanation. Members, any questions? I'll take a stab. Oh, Representative Hardaway, you're recognized, sir. Oh, thank you, sir. Yes, a quick question. The 3%, 5% increases, are those automatic, or are those limits that would have to be examined on a year-by-year basis and then voted on? Or could you help clarify that just a little bit?
I do not know the answer to that question. Could we ask Holt Witt, maybe?
Okay. Yes, we're going to go out of session for just a moment. We're out of session. If you would please identify yourself and who you're with.
Thank you, Chairman. Holt Witt, Department of Health. I just pulled up the amendment. The amendment reads, sorry. The permit fee, as established under the rule of this section, may be increased by up to 3% during a calendar year and up to 5% during a 5-year period. So this sets some guardrails in which the department can operate in when we begin the rulemaking process.
So does that mean that you will keep any increases below that amount, or does it mean that that amount will be increased each year by that percentage?
No, sir. That means that if we were to promulgate rules to raise our fees, we would only be allowed to propose up to 3% per calendar year and no more than 5% over a 5-year period.
Thank you. Appreciate that. Thank you so much. All right, members, any other questions while we're out of session? Oh, Representative Hardaway.
Thank you, Chairman. Just a couple of quick ones on the,
And are these questions for our guest or are they for the sponsor?
I'll wait.
Okay. All right, members, any other questions for our guest? All right, wait, Chairman Crawford, you're recognized.
Thank you, Mr. Chairman. Thank you for being here, Mr. Witt. My question is the 3% and the 5% for the permits there. The county clerks are already doing this now. This will not be a new procedure for them, correct?
You're recognized.
Thank you, Chairman Crawford, for the question. This only pertains to the food code inspection fees. So any other fees that your clerks are raising by that amount would not be impacted by this bill.
Chairman Crawford?
I'm not sure I asked the question correctly. Does the county clerks do this now, or is this going to be a new process for them?
No, sir. The county clerks do not do this now. The Department of Health conducts all the food inspections for certain establishments. Department of Agriculture does others. Our current inspection fees are in statute. So they're at a set amount in statute currently at present. We're proposing to move those to rule. And then in doing so, we've agreed to some terms with the food service industry on how much we could increase them via rule in the future.
Thank you.
Thank you for that. Representative Hardaway, third time's a charm.
Well, we'll see. Morning, sir.
Morning.
On the maintenance of required files for drivers or contractors for delivery of food, why the changes there?
Thank you for the question, Representative Hardaway. We had some statutes in place previously that we discovered during our retrospective rulemaking project that I know this committee is familiar with. And we found some statutes that were antiquated. For example, back when restaurants used to have dedicated delivery drivers, there was a statute in place that said the department must inspect their insurance information. Obviously, there's a lot of other insurance-related statutes in place. And so we felt like it was unnecessary, particularly with the food service apps and other things out there that most restaurants use now.
That's a curious answer. If it's not a food service app, would independents be covered? Is there any way to guarantee that independents would be covered?
Anyone operating a vehicle in the state of Tennessee is required to have car insurance. And we have, if a food delivery app like, well, I won't use a name, but if a food delivery app has a driver working for them as a third party, we would have no way to inspect them anyway because we wouldn't know who's working for that restaurant. So it became antiquated several years ago when we were doing our retrospective rulemaking project. We thought it was best to clean that up.
All right, I'm not sure about that part, but I'll take that with you offline. On the Mr. Chairman, I've lost my spot, so I'll take that up with them. Oh,
Please.
on the inspections of these B&B, Airbnb spots, why are you reducing the inspections?
Thank you for the question. In talking with our safety inspectors, the instances in which there are any incidents at bed and breakfast are extremely low. And as Representative Helton Haynes mentioned in her opening comments, this would align them more closely with other hotel type establishments across the state. So we are two reasons. One, the incidence of any issues are very low, and two, this would be more of a fairness issue to align them with other hotel type industries.
Another curious response there. Hotels have a lot of safeguards built in just through their corporate structure. And certainly there are some other issues that are addressed in other parts of the law. However, I would think that from my experience, I've gotten more complaints on these Airbnbs than I have on hotels. So I'm wondering why we're taking that oversight, that inspection aspect out.
Thank you for the question. I think I better understand it now. This does not impact Airbnbs whatsoever. These are true bed and breakfast. There's about 40 of them in the state. This has nothing to do with the short-term rental industry. We do not inspect those.
So the bed and breakfasts would not have the frequent inspections, but the Airbnbs would.
I believe that Airbnbs are inspected. I think that's a local issue. Again, it has nothing to do with the Department of Health. The Department of Health inspects true bed and breakfasts, which are, often in older homes or in hotel-like settings that are licensed as a bed and breakfast. It is not a short-term rental type property.
All right. Thank you, Chairman. I don't see how we have a clear line delineating those services and what they offer to the public and the risk associated with those services. And I'll take that up with you later. Thank you. Thank you, Chairman.
Thank you, Representative Hardaway. Representative Renaud, did you want to speak to Mr. Witt?
I'll skip.
Okay, all right. We've got to pass there. Chairman Reedy.
Mr. Whitten, for clarification, we were just having a sidebar conversation. We are not, passage of this legislation will not put a burden on our counties in any way, shape, or form.
No, sir.
And then as this being Government Operations Committee, in the rulemaking authority being given, you will be coming back to us with those rules when we discuss this further, correct?
Yes, sir. Looking forward to it.
Okay. I just want to make the committee members aware of that. Thank you, sir.
Thank you for that, Chairman. Members, any other questions for our guest? Seeing none, we're going to go back into session. Chair Lady Haynes, any follow-up comments, or would you like to go ahead and call question?
I'll just renew my motion.
All right. Members, we've going to open up the vote. Oh, I'm sorry. Representative Renaud, did you? Okay. Mr. Clerk, open the vote. Anyone else needing to place their vote? Anyone wish to change their vote? Clerk, please take the vote. Oh. I'm good. Okay.
Mr. Chairman, the vote is 14 ayes and 0 noes.
All right. And you are on your way to Finance, Ways and Means. Third item. Oh, I'm sorry. We're going to jump down to item number 8 by Representative Martin. That's House Bill 782. Representative, you are recognized. Oh, I'm sorry. We need a motion and a second. We have a motion and a second. You're recognized.
Thank you, Chairman and Committee. PACE stands for a program of all-inclusive care for the elderly, and a PACE program allows frail older adults to safely remain living in the community. PACE provides all services at one location and allows those being served to continue to live in their homes. This legislation requires the TennCare Bureau to authorize one additional program in either West Tennessee or Middle Tennessee, and it allows an expansion for the one that's in Hamilton County to surrounding counties. With that, Mr. Chairman and Committee, I'm happy to answer questions.
Thank you for that explanation. Members, do we have any questions? We have a question on the bill. Clerk, please open the vote. Everyone knows what to do. Looks like everyone's voted. Clerk, please take the vote.
Mr. Chairman, the vote is 15 ayes and 0 noes.
Your bill passes forward to Finance, Ways and Means.
Thank you.
All right. Now let's get back to item number 3, House Bill 910 by Chairman Garrett. We have a motion and a second. You are recognized, sir. Oh, it's been brought to my attention that you have an amendment traveling with this bill. I'm sorry, proposed for addition. All right. What's your amendment number?
I have the amendment, Mr. Chairman, 6782.
That's what we're showing. We
Which
have a
makes
motion
the
on
bill.
amendment. We have motion, we have a second. Let's go ahead and add that amendment to the bill. All those in favor of adding the amendment indicate by saying aye. Any opposed? The ayes have it. You are properly amended. Would you please explain your amendment, please?
I will. Thank you, Mr. Chairman. And just for clarification purposes, that amendment from the Commerce Committee only changes the amount of employees that might come from the Human Rights Commission over to the Attorney General. They increased it by 3. That wasn't the intent of legislation, so we've got it back down to 33. That's the only substantive change in that amendment that y'all just placed on. So I just wanted to explain that real quick.
Thank you.
Committee, what this bill does is the Human Rights Commission will be transferred over the authority and purview of our Attorney General, and it'll create a new division of civil rights enforcement that will enforce the claims in the discrimination world as it relates to the Human Rights Commission, what they handled. It'll now be handled under the Attorney General's office. A couple other things that it adds a new type of discrimination in the education world that's currently not part of what we prosecute and hopefully prevent from happening. So with that, Mr. Chairman, I'll be glad to take any questions.
Thank you for that explanation. Members, do we have any questions for the sponsor? Representative McKenzie, you're recognized.
Thank you, Mr. Chair. So the amendment that we received, it's fairly lengthy, like 65-page amendment. You're saying that the only thing it does was remove 2 employees. There's no other change within that?
You're recognized.
Yes, the first draft, the fiscal review assumed there was going to be 3 employees in the Department of Human Services that would handle some reporting requirements. It assumed that that was in addition to the current employees that are under the commission as it exists now. That was not the intent. So we have changed that amendment to reflect the same amount of employees that currently exist in the Human Rights Commission will be transferred over to the Civil Rights Enforcement Division of the AG's office. So there's no increase in employees, which will in turn create a fiscal note.
Do you have a follow-up?
Yes. Thank you, Mr. Chair. So I'm assuming this piece of legislation is before us because something was not correct. It wasn't not as much value added. And this is going to increase, well, I guess it's not increasing efficiency since we're not reducing any employees. What is the reason for doing away with the Human Rights Commission as we know it and putting it under an agency that gives opinions?
You're recognized.
There are 2 things I disagree with in the premise of your question. One is that we're not essentially getting rid of anything. We are transferring the authority of the Human Rights Commission in its entirety to the purview of the Attorney General and creating a new Civil Rights Enforcement Division. So 1, we're not getting rid of anything. We're not getting rid of any type of claim that someone may or may not have that needs to be investigated regarding whatever they've been discriminated against. Secondly, I disagree with your statement that the Attorney General's office only provides opinions. If that's what you think that our Attorney General's office does, you are wholly inaccurate of what our Attorney's General office does, the enforcement for civil matters as it relates to the state of Tennessee. They represent the state of Tennessee. They do many, many things involved in many, many litigation that has received dollars in the pharmaceutical world, et cetera, back here. So they do a whole lot more than just provide opinions, as you state in the premise of your question. So part of the reason why I support this legislation is because if we continue to have these matters before the Human Rights Commission, which they do a fine job of doing, my concern is the claims aren't going away. There's still folks that think they can get away with discriminating against folks for their housing, discriminating folks against their education opportunities, whatever those may be. And I think if someone receives a letter or an action that the Attorney General is investigating their actions. I think that's going to perk up some people. I think that's going to make people hopefully say, what have I done to attract the Attorney General of the state of Tennessee, who has the full authority to investigate claims that I might have been involved in? Will that be a deterrent? Could that say to folks, I'm not going to be doing this anymore. I'm not going to participate in these types of action where I'm going to discriminate against anybody. Hopefully these claims will be streamlined. They'll be investigated to the full extent of the AG's power to make sure folks don't discriminate against other folks in this state. That's the reason why I believe this legislation is so important.
Last follow-up, please.
Thank you, Mr. Chair. We can agree to disagree definitely on on our first point. Independence matters. Autonomy matters. From your answer, it sounded like the HRC wasn't doing something in terms of getting behind, and their authority wasn't enough, and now we have to give it more authority, that a letter coming from the AG's office is going to give it more authority than it has now. I guess I fundamentally disagree with that premise. And I do think the Human Rights Commission will be reconstituted. That's why we're here under the AG. So I don't think this is a direct transfer. All the rules and everything moves over. I think there's going to be a process and a reconstitution, and that's what, quite frankly, concerns me in this action. Could you cite a few ways, my last question, that the Human Rights Commission is currently constituting, as you said, they're going to do better on the other side, that they failed our citizens in the state over the last few years, 5 years?
You're recognized.
Thank you, Mr. Chairman. This piece of legislation is not about one organization to the other regarding their failures or their successes, right? It's about making the organization, making claims that we have as a state that we're bound to investigate, making that process better, more efficient, and hopefully deter the action of discrimination in this state as it relates to some civil claims that can be prosecuted by the AG's office. So you have someone that's subject now to a Human Rights Commission where they get information from them. They might even know what that is, right? Again, not saying anything wrong with the Human Rights Commission, but if they get something from the Attorney General's office, my belief, my hope is that any action subsequent to that somebody else may say, they may talk to their neighbor, they may talk to their business partner, they may talk to someone and say, my goodness, I just got a letter from the Attorney General's office. From a legal perspective, the most powerful legal perspective, legal person in our state is investigating some type of claim that I've been accused of. I think that's going to get the attention of that person. I think that's going to get attention of others. And my hope that that acts as a deterrent for these type of actions. I don't think we currently have that as it exists to this day.
Representative Clemens, you're recognized.
Thank you, Mr. Chairman. So with regard to these 30 existing positions, this amendment expressly allows the Attorney General to do whatever he wants with them and utilize them however he wants. Does that include terminating them or using them specifically for this purpose?
You're recognized.
Thank you, Mr. Chairman. This division will be transferred. These 33 positions will be transferred over to the Attorney General's office. And yes, just like any purview, they can do what they need to do to make sure that they respond, investigate appropriately to the fullest extent they're allowed to any claims of discrimination that any Tennessean has. So I would hope they would look at this at a whole, look to see how can we make it better? How can we make it more efficient? So certainly those will come down to some questions regarding who does a particular job under the Civil Rights Enforcement Division. I would hope that they would have that ability to make sure that they can do the best way forward of investigating and eliminating these discrimination claims.
Representative Clemens.
Thank you, Mr. Chairman. And yeah, this amendment expressly says the Attorney General has the discretion to determine how and whether to utilize these positions. So I guess it raises a question for me as to whether or not these people and their institutional knowledge and experience with this subject matter are going to be fully utilized by this Attorney General, whose budget we have increased exponentially, whose staff we have increased exponentially, so he can carry out these political lawsuits across the state of Tennessee. My next question is, in Section 11, with regards to protecting against discrimination in education. You expressly exclude discrimination on the basis of disability. Why is that?
You're recognized.
It's already covered in already federal law.
Well, so is race, color, and national origin. Those are protected classes. How come disability isn't expressly included in here, nor is religion?
You're recognized.
Because none of that's changing. No laws like that are changing whatsoever on the books. You can make your political statements all you want for a political crowd that thinks that's what's happening here, but nothing is happening as it relates to what is currently protected. No class, no subject matter, no nothing is changing whatsoever as it relates to someone having a claim based upon if you're a protected class or not, whether or not you can file a lawsuit or relieving any protection you have under the federal law. There's nothing like that that's changing whatsoever. In fact, most, if not all, the substantive law that currently exists that empowers the Tennessee Human Rights Commission is not changing as it's transferred over to the AG. We're just simply adding an additional way that someone could be discriminated against in the education space. We're adding that as a potential claim so they can investigate the repercussions of that discrimination. So there's nothing being eliminated whatsoever.
You cut them off. Representative Clemens, last follow-up, please.
Thank you. So even under the definition of discriminatory practice, we're not including disability. And then we're expressly excluding it from education discrimination as well as religion. I don't understand why we would purposely exclude it from that section, regardless of whether or not it's protected. I mean, we all know it's protected by federal law, but in this provision, we're not including this in the state statute. I just don't understand why we'd exclude disability or religion from discrimination.
You're recognized, sir.
And once again, that's not an exclusion for someone to pursue that. So I'm not really sure your confusion, but that's where we are. There's no excluding a potential cause of action that currently exists today.
But we're authorizing and empowering the Attorney General to file these claims under a new Civil Rights Enforcement Division, which I don't have a problem with the premise of a Civil Rights Enforcement Division. I think that's a worthwhile endeavor, and it should be housed within the Attorney General and Reporter's Office to specifically focus on those claims. But if I'm looking at this and saying, oh, well, you know, what is a discriminatory practice? Well, if somebody discriminates based on disability, the statute doesn't cover that. And so I guess I'm not, this isn't a gotcha question. I'm just asking you, why isn't it included in here expressly?
You're recognized.
Thank you, Mr. Chairman. Again, I'll go for my former statements. I get that it's not a gotcha statement, but we're not eliminating any type of cause of action that someone may have for a claim made by the Tennessee Human Rights Commission that's be transferred to the AG. And it's not the AG filing the claims. It's actually the person that would be subject to the discrimination filing the claims. We're not reducing any claim that they can be made as it exists from transferring it where it is now to the Civil Enforcement Division of the AG's office.
You're recognized. And last one, please. We're running short on time here, Chairman.
Well, this is a pretty substantive piece of legislation, Mr. Chairman. I appreciate it. So we're especially laying out here that it's a discriminatory practice in violation of this chapter for a person to deny admission to a school or school program or activity on the basis of race, color, or national origin. But we're purposely excluding that. I just don't understand why that would be. You know, again, the Civil Rights Enforcement Division is a worthwhile endeavor. I don't know why we're transferring over and reconstituting or who on the current commission we have an issue with. But I do have a concern with this Attorney General making political decisions rather than legal decisions. And to the extent that threatens the civil rights of the citizens of Tennessee, I think we need to take a very, very careful look at that and close examination to make sure that that's not the case so that we carry out the spirit of what you say this legislation is.
You're recognized.
Thank you, Mr. Chairman. If I may, there's not in the new education discriminations, there's also the claim that Chairman Clemens is referring to. So I would say there's nothing being eliminated whatsoever in the new division for discrimination in the education space. There's nothing being eliminated for any type of disability. Those claims already exist. That's usually a standalone claim. So it's not eliminating a single thing on what can already be investigated by the Human Rights Commission, Mr. Chairman. So thank you for that.
Thank you. Representative Hardaway, you're recognized.
Thank you,
Please,
Chairman.
Representative, we are getting short on time, sir.
All right, thank you. I'm having a hard time understanding why the AG would be a better suited to carry out investigations and subsequent enforcement of these claims. I've been looking at this since I got here in 2007. That's when the attempts to eliminate the Human Rights Commission was, from my understanding, it's first started. At least first started for me. But I'm a couple of things real quick. Why is it that the institutional racism that we find sometimes in government, why is it better suited for the Attorney General to pursue it as opposed to an independent with a great degree of autonomy as opposed to answering to the AG?
You're recognized.
Thank you, Mr. Chairman. And I hope that it roots out these claims for discrimination. The Attorney General's office handles the Consumer Protection Division. Any type of products, any type of items that are in our commerce, they have a division solely created to protect the consumer. They have the experience, they have the lawyers, they have the wherewithal, they have the power of the Attorney General's office to enforce how someone might be manipulated in commerce in the market. And I think they are very good at what they do. My hope is that this will create the exact same thing for the Division of Civil Rights Enforcement, that they will be better than what we've had in the past. There's no guarantee, Representative Hardaway. That's the way it's going to be. There's absolutely no guarantee. But my hope, my wish is that if they do, and this Civil Rights Division does what I believe the Attorney General's office can do, that it's going to root out discrimination. It's going to root out all discrimination in Tennessee. I hope. Of course, we're not going to be able to guarantee the elimination of it, but with what they've done for the Consumer Protection Division and how they fight for everyday Tennesseans, that's what they hope I do. That's what I hope they do with this
All right,
Civil
and
Rights Division.
I appreciate all of the detail. The Title VI, rather. Why was that transferred, or why are those responsibilities for Title VI transferred to HR
You're recognized.
instead of the AG?
We are required, thank you, Mr. Chairman. We are required under Title VI to report to the federal government under Title VI. That reporting mechanism we're giving to the Department of Human Services. They will be able to report back to the federal government under Title VI for that purpose. And that's the division that we're assigning for that responsibility.
So the,
And Representative Hardaway, would you like to have a final follow-up?
yes, sir. So the execution, the enforcement aspects are still going to reside with the AG. And I'm going to go ahead and finish up. I don't understand what the genesis was for you to take this on. Is it somehow related to the reverse discrimination?
Representative Garrett, feel free to take that however you can.
I don't know how to respond to your last portion of that. But to answer your first question regarding the reporting requirements, that'll be the only thing handled by the Department of Human Services. Everything else, the enforcement execution that you referred to in your first question, will still be a function of the new Division of Civil Rights Enforcement under the AG's office.
Thank you for that explanation. All right, members, we are short on time here. We're going to go ahead and move this to a vote. Clerk, could you please open the board? Members, all in favor, you know what to do. Everybody voted? Anyone to change a vote? All right. Clerk, please take the vote.
Mr. Chairman, the vote is 7 ayes and 5 noes.
Thank you, Clerk. You're on your way out to Finance, Ways and Means. Members, we are up to 12 noon here again. Representative Hawk, Chairman Hawk, I feel like I've done this to you more than once. All right. We have a motion on the bill. We have a second. Chairman Hawk, you are recognized on House Bill 964.
Thank you, Chairman and members. This legislation is a housekeeping bill for architects to coordinate with the Department of Education and Safety and the Fire Marshal's Office. It's going to keep our students safe through safety glass measures.
We have a question on the bill. Members, we're ready to vote. Clerk, open the board, please. Everyone voted. Anybody wish to change a vote? All right, clerk, please take the vote.
Mr. Chairman, the vote is 12 ayes and 0 noes.
Thank you for that. Chairman Hawk, your bill passes out. Finance, Ways and Means. Committee, I'm sure you'll be disappointed to hear this, but not nearly as disappointed as the sponsors. Folks, due to our time restraints today, we are going to have to roll this to next week. I apologize. With that, we are adjourned.